Hi, it's Merrina again. Welcome back to Reading with Better with Atual Gawande with me. Yesterday we read chapter 4, which is called Naked. It's talked about how to maintain propriety in medical practice. And today we're reading chapter 5. It's called What Doctors Owe, and I think it talks about medical malpractice. So it's an interesting topic. Let's start reading it. It was a traditional day at the Middlesex County Superior Court in Cambridge, Massachusetts. 52 criminal cases and 147 civil cases were in session. In courtroom 6A, Daniel Cattrall was on trial on 3 counts on rape and 3 counts of assault. In courtroom 10B, David Santiago was on trial for cocaine trafficking and illegal possession of deadly weapon. In courtroom 7B, a scheduling conference was being held by Minahan versus Wallinger, a civil claim of motor vehicle negligence. In the next door, in courtroom 7A, Dr. Kenneth Reed faces charges of medical malpractice. I can see the tension building up in here. Reed was a Harvard-trained dermatologist with 21 years of practice, and he has never been sued by malpractice before. That day, he was being questioned about 2 office visits and a phone call that had taken place almost a decade earlier. Barbara Stanley, a 58-year-old woman, had been referred to him by an internist in the summer of 1996 about a dark, warty nodule a quarter-inch wide on her left thigh. In the office, under local anesthesia, Reed shaved off the top for a biopsy. The pathologist's report came back a few days later with a near-certain diagnosis of skin cancer, a malignant melanoma. At a follow-up appointment, Reed told Stanley that the growth would have to be completely removed. This would require taking a 2-centimeter margin, almost an inch, of healthy skin beyond the lesion. He was worried about metastasis and recommended that the procedure be done immediately, but she balked. The excision he outlined on her leg would have been 3 inches across, and she couldn't believe that a procedure so disfiguring was necessary. She said that she had a friend who had been given a diagnosis of cancer erroneously and undergone unnecessary surgery. Reed pressed, though, and by the end of the discussion, she allowed him to remove the visible tumor that remained on her thigh, only a half-inch excision for a second biopsy. He, in turn, agreed to have another pathologist to look at all the tissues and provide a second opinion. To Reed's surprise, the new tissue specimen was found to contain no sign of cancer, and when the second pathologist, Dr. Wallace Clark, an eminent authority on melanoma, examined the first specimen, he concluded that the initial cancer diagnosis was wrong. "I doubt if this is melanoma, but I cannot completely rule it out," his report said. Reed and Stanley spoke by phone in mid-September 1996 to go over the new findings. None of this was in dispute. What was in dispute was what happened during that phone call. According to Stanley, Reed told her that she did not have melanoma at all. The second opinion on the original biopsy was negative, and that no further surgery was required. Reed recalled the conversation differently. "I indicated to Barbara Stanley that Dr. Wallace Clark felt that it was a benign lesion called a spitz nevus, and that he could not be 100% sure if it was not a melanoma," he testified. "I also explained to her, in Dr. Clark's opinion, that lesion had been adequately treated, and that follow-ups would be necessary, and that Dr. Clark did not feel that further surgery was critical. I also explained to Barbara Stanley that this was in conflict with the previous pathology report, and that the most cautious way to approach this would be to allow me to remove additional skin for a 2 centimeter margin. She became furious at him for the seeming error in his initial diagnosis, though, and told him that she did not want more surgery. At that point, I re-emphasized to Barbara Stanley that at least she should come in for a regular follow-up. She did not want to return to see him. Indeed, she wrote him an angry letter afterward, accusing him of mistreatment and refusing to pay his bill. Wow, this woman seems very angry right now. If I were the doctor, I would be a little bit scared. But it seems like there was a misunderstanding of what they were talking about. The doctor wanted to be more conservative, and he wants to remove this thing, even though it doesn't seem like it was bad. But the woman just tried to blame the doctor. 2 years later, the growth reappeared. Stanley went to another doctor, and this time the pathology report came back with a clear diagnosis: a deeply invasive malignant melanoma. A complete excision, she was told, should probably have been done the first time around. When she finally did undergo the more radical procedure, the cancer had spread to the lymph nodes in her groin. She was started on a year-long course of chemotherapy. 2 months into it, she suffered a seizure. The cancer had spread to her brain and her left lung. She had a course of radiation. A few weeks after that, Barbara Stanley died. But not before she had called a lawyer from her hospital bed. She found a full-page ad in the Yellow Pages for an attorney named Merrina Lan, a specialist in medical malpractice cases, and he visited her at the bedside that very day. She told him that she wanted to sue Kenneth Reed. Lang took the case. 6 years later, on behalf of Barbara Stanley's children, he stood up in a Cambridge courtroom and called Reed as his first witness. It seems like I would think that the doctor, he wasn't very sure if it was cancer, but he did tell the woman that it's better to remove it, but the woman didn't want to because she thinks it was very bad to look at after the surgery. So I'm not sure what's going to happen. Let's keep reading to find out. Malpractice suits are a feared, often infuriating, and common event in the doctor's life. I have not faced a bona fide malpractice suit yet, but I know to expect one. The average doctor in high-risk practice like surgery or obstetrics is sued about once every 6 years. 70% of the times, the suit is either dropped by the plaintiff or won by the doctor in the court. But the cost of defense is high, and when the doctor loses, the average jury verdict is $500,000. Wow, that's a lot of money. General surgeons pay anywhere from $30,000 to $300,000 a year in malpractice insurance premiums, depending on the litigation climate of the state they work in. Neurosurgeons and obstetricians pay upward of 50% more. This is a system that seems irrational to most physicians. Providing medical care is difficult. It involves the probability of any of 1,000 missteps, and no doctor will escape making some terrible ones. Lawsuits demanding 6-figure sums for bad outcomes, therefore, seemed most malicious to physicians, and even worse when no actual mistake was involved. Every doctor, it seems, has a crazy lawsuit story. My mother, a pediatrician, was once sued after a healthy 2-month-old she had seen for a routine checkup died of sudden infant death syndrome a week later. The lawsuit alleged that she should have prevented the death, even though a defining characteristic of SIDS is that it occurs without warning. One of my colleagues performed life-saving surgery to remove a woman's pancreatic cancer, only to be sued years later because the woman developed a chronic pain in her arm. The patient blamed it, implausibly, on potassium she received by the IV during recovery from the surgery. I have a crazy lawsuit story of my own. In 1990s, while I was in medical school, I was standing at a crowded Cambridge bus stop when an elderly woman tripped on my foot and broke her shoulder. I gave her my phone number, hoping that she would call me and let me know how she was doing. She gave the number to a lawyer, and when he found out it was a medical school exchange, he tried to sue me for malpractice, alleging that I had failed to diagnose a woman's broken shoulder when I was trying to help her. A marshal served me with a subpoena in a physiology class. When it became apparent that I was a first-week medical student and hadn't been treating the woman, the court disallowed the case. The lawyer then sued me for $500,000, alleging that I'd run his client over with a bike. I didn't have a bike, but it took a year and a half and $15,000 in legal fees to prove it. Wow, this sounds just crazy. It seems like people can sue doctors for anything, and lawyers can make up facts that aren't even real. I'm really surprised by all the crazy stories that he shared here, and I think I need to be prepared for whatever career I pursue in the medical field, because if I get sued for something very stupid, I would definitely not be happy. My trial had taken place in the same courtroom as Reed's trial, and a shudder went through me when I recognized it. Not everyone, however, see the system the way doctors do, and I had come in an attempt to understand that gap in perspectives. In the courtroom gallery, I took a seat next to Ernie Brown, the son of Barbara Stanley. He was weary, he told me, after 6 years of excruciating delays. He worked for a chemistry lab in Washington State and had to take vacation time and use money from his savings to pay for hotels and flights, including for 2 trial dates that were postponed as soon as he arrived. I wouldn't be here unless my mother asked me to, and she did before she died. She was angry to have lost all those years because of Reed. He was glad that Reed was being called to account. The dermatologist sat straight-backed and still in the witness chairs as Lang fired questions at him. He tried not to get flustered. A friend of mine, a pediatric plastic surgeon who had had a malpractice suit go to trial, told me the instructions that his lawyer had given him for his court appearance. Don't wear anything flashy or expensive. Don't smile or joke or frown. Don't appear angry or uncomfortable. And don't appear overconfident or dismissive either. How then are you supposed to look? Reed seemed to have settled on simply looking blank. He parsed every question for traps, but the strenuous effort to avoid mistakes only made him seem anxious and defensive. Wouldn't you agree, Lang asked, that melanoma is very curable if it's excised before it has had a chance to spread? If a patient had asked this question, Reed would readily have said yes, but with Lang asking, he paused, unsure. It's hypothetical, Reed said. Lang was delighted with this sort of answer. Reed's biggest problem, though, was that he hadn't kept notes on his mid-September phone conversation with Barbara Stanley. He could produce no corroboration for his version of events. And, as Lang often reminded the jury, plaintiffs aren't required to prove beyond a reasonable doubt that the defendant had committed malpractice. Lang needed 10 of 12 jurors to think only that it was more likely than not. This seems a little bothering for me because the lawyer doesn't really need concrete proof that there has been a malpractice. So theoretically, if the lawyer is good enough with persuading people, then he could win the malpractice suit. You documented a telephone conversation that you had with Barbara Stanley on August 31st. Isn't that correct? Lang asked. That is correct. Your assistant documented a discussion that you had with Barbara Stanley on August 1st, right? That is correct. You documented a telephone call with Malden Hospital, correct? That is correct. You documented a telephone conversation on September 6th when you gave Barbara Stanley a prescription for an infection, correct? That is correct. So you made efforts, and you had a habit of documenting patient interaction and phone conversations, right? That is correct. Lang began to draw the threads together. Exactly what Barbara Stanley needs, according to you, was a 2-centimeter excision, right? Which is what I instructed Miss Stanley to do. Yet you did not tell Dr. Hodgman, Stanley's internist, that she needed a 2-centimeter excision, right? That is correct. But you want this jury to believe that you told Barbara Stanley. I want this jury to believe the truth, which is that I told Barbara Stanley that she needed a 2-centimeter excision. Lang raised his voice. You should have told Barbara Stanley that. Isn't that correct? He all but called Reed a perjurer. I did tell Barbara Stanley repeatedly, Reed protested, but she refused. Reed tried to keep his exasperation in check, while Lang did all he could to discredit him. In your entire career, Doctor, how many articles have you published in the literature? Lang asked at another point. 3, Reed said. Lang lifted his eyebrows and stood with his mouth agape for 2 beats. In 20 years' time, you've published 3 articles? Doctor, you do a lot of cosmetic medicine, isn't that true? He later asked. I could not tell whether the jury was buying Lang's insinuations. His examination made my skin crawl. I could picture myself on the stand, being made to defend any number of cases in which things didn't turn out well, and I hadn't got every last discussion down on paper. Lang was 60 years old, bald, short, and loud. He paced constantly and rolled his eyes at Reed's protestations. He showed no deference and little courtesy. He was almost a stereotype of a malpractice lawyer, except in one respect, and that was the reason I'd come to watch this particular trial. Barry Lang used to be a doctor. What? A malpractice lawyer used to be a doctor? I want to know why he changed from being a doctor to a lawyer. I personally know a doctor who used to be a lawyer, but she found out that she hated being a lawyer, and then she went back to school and became a doctor. I did not know people would go the other way. For 23 years, he had a successful practice as an orthopedic surgeon with particular expertise in pediatric orthopedics. He had even served as an expert witness on behalf of other surgeons. Then, in a turnabout, he went to law school, gave up his medical practice, and embarked on a new journey suing doctors. Watching him, I wondered, had he come to a different understanding of doctors' accountability than the rest of us? I went to meet Lang at his office in downtown Boston, on the 10th floor of 1 State Street, in the heart of the financial district. He welcomed me warmly, and I found that we spoke more as fellow doctors than as potential adversaries. I asked why he had quit medicine to become a malpractice attorney. Was it for the money? He laughed at the idea. Going into law was a money disaster, he said. Starting out, he had expected at least some rewards. I figured I'd get some cases, and if they were good, the doctor would settle them quickly and get them out of the way. But no, I was incredibly naive. No one ever settles before the actual court date. It doesn't matter how strong your evidence is, they always think they're in the right. Things can always change over time, and given the choice of paying now or paying later, which would you rather do? He entered law practice, he said, because he thought he'd be good at it, because he thought he could help people, and because, after 23 years in medicine, he was burning out. It used to be 2 hip replacements today. Yay, he recalled. Then it became 2 hip replacements today. Ugh. When I spoke to his wife, Janet, she said that his decision to change careers shocked her. From the day she met him when they were undergrads at Syracuse universities in New York, he had never wanted to be anything other than a doctor. After medical school in Syracuse and an orthopedic residency at Temple University in Philadelphia, he had built a busy orthopedic practice in New Bedford, Massachusetts, and led a fulfilling and varied life. Even when he enrolled in night classes at Southern New England School of Law, a few blocks from his office, she didn't think anything of it. He was, as she proved, forever going to school. One year, he took English literature classes at a local college. Another year, he took classes in Judaism. He took pilot lessons before long was entering airplane aerobatics competitions. Law school, too, began as another pastime. It was just for kicks, he said. This guy seems so interesting. He continues taking classes even though he was already a practicing physician and he has so many different interests. I think he's probably incredibly smart and, I don't know, able to do a lot of things. After he finished, though, he took the bar exam and got his license. He got certified as a public defender and took occasional cases defending indigent clients. He was 50 years old. He had been in orthopedic practice long enough to have saved a lot of money, and law began to seem so much more interesting than medicine. In July 1997, he handed his practice over to his startled partners, and that was the end of it, he said. He figured that the one thing he could offer was his medical expertise, and he tried to start his legal practice by defending physicians. But because he had no experience, the major law firms that dealt with malpractice defense wouldn't take him, and that malpractice insurers in the state wouldn't send him cases. So he rented a small office and set up shop as a malpractice attorney for patients. He sunk several $1,000s a month into ads on television and in the phone book, dubbing himself the law doctor. Then the phone calls came. 5 years into his new career, his cases finally began going to trial. This was his 8th year as a malpractice attorney. He had won settlements in at least 30 cases. 8 or others had gone to trial, and he had won most of them too. 2 weeks before the real trial, he won a $400,000 jewelry award for a woman whose main bile duct was injured during a gallbladder surgery and required several reconstructive operations. Lang got more than a third of that award. Under Massachusetts state law, attorneys get up to 40% of the first $150,000, 33.3% of the next $150,000, 30% of the next $200,000, and 25% of anything over half a million. Lang had at least 6 cases pending. If he had any money troubles, they are over now. Lang said he received 10 to 12 calls a day, mostly from patients and their families, some referrals from lawyers who don't do malpractice. He turns most of them away. He wants a good case, and a good case has to have 2 things, he said. Number 1, you need the doctor to be negligent. Number 2, you need the doctor to have caused damage. Many of the cases fail on both counts. I had a call from one guy, he said. I was waiting in the emergency room for 4 hours. People were taken ahead of me, and I was really sick. I said, well, what happened as a result of that? Nothing, but I shouldn't have to wait for 4 hours. Well, that is ridiculous. Some callers have received negligent care, but suffered little harm. In a typical scenario, a woman sees her doctor about a lump in her breast and is told not to worry about it. Still concerned, she sees another doctor, gets a biopsy, and learns that she has cancer. So she calls me up. She wants to sue the first doctor. Lang said, well, the first doctor was negligent, but what are the damages? She got a timely diagnosis and treatments. The damages are nothing. I asked him how great the prospective damages had to be to make the effort worth his while. It's a gut thing, he said. His expenses on a case are typically $40,000 to $50,000, so he would almost never take, say, a dental case. Is the jury going to give me $50,000 for the loss of a tooth? The answer is no. The bigger the damage, the better. As another attorney told me, I'm looking for a phone number. Damage worth 7 figures. Oh my gosh, this part is really crazy to read about. I can understand how malpractice attorneys can make so much money, but it's also scary to think that any small mistake a doctor makes will end up in like really huge damages to patients and a lot of loss in malpractice suits in the future. That is quite scary to think about. Another consideration is how the plaintiff will come across to jurors. Someone may have a great case on paper, but Lang listened with the jury in mind. Is the person articulate enough? Will he or she seem unreasonable or strange to others? Indeed, a number of malpractice attorneys I spoke to confirmed that the nature of the plaintiff, not just the injury, was a key factor in the awarding of damages. Vernon Glenn, a highly successful trial attorney from Charleston, South Carolina, told me, the ideal client is someone who matches the social, political, and cultural template of where you are. He told me about a case he had in Lexington County, South Carolina, a socially conservative, devotedly Christian county that went 72% for George W. Bush in the 2004 election and produces juries unsympathetic to malpractice lawyers. But his plaintiff was a white Christian female in her 30s with 3 young children who had lost her husband, a hard-working 39-year-old truck mechanic who loved NASCAR, had voted Republican for the past 20 years, and had built the addition to their country home himself to a medical error. During routine gallbladder surgery, doctors caused a ball injury that they failed to detect. His wife called several times about his worsening pain after he was discharged home from the hospital, but she was told to just give him more pain medication until he collapsed and died. The woman was articulate and attractive, but not so good-looking as to put off a jury. She wasn't angry or vengeful, but was visibly grieving and in need of help. If the family hadn't spoken English, if the husband had a long history of mental illness or alcoholism or cigarette smoking, if they had been involved in previous lawsuits or had a criminal record, Glenn might not have taken the case. As it was, she was darn close to the perfect client. He said, the day after the trial, the defendants settled for $2.4 million. Geez, that's a lot of money. And it's interesting to see that winning a lawsuit isn't about just the evidence. It's also about whether the client would make the make the jury like them. Out of the 60 callers a week, Barry Lang might take the next step with two and start in reviewing the medical records for hard evidence of negligent care. Many law firms have a nurse or a nurse practitioner on staff to do the initial review, but Lang himself gathers all the records, arranges them chronologically, and goes through them page by page. There is a legal definition of negligence when a doctor has breached his or her duty of care, but I wanted to know his practical definition of the term. Lang said if he finds an error that resulted in harm and the doctor could have avoided it, then, as far as he is concerned, the doctor is negligent. To most doctors, this is an alarming definition, given the difficulty of many cases, unclear diagnosis, delicate operations. We all cause serious complications that might have been avoided. I told Lang about a few patients of mine. A man with severe bleeding after laparoscopic liver surgery, a patient who was left permanently hoarse after thyroid surgery, a woman whose breast cancer I failed to diagnose for months. All were difficult cases, but in looking back to them, I also see ways in which I could have done better. Would he sue me? Could he show a jury how I might have avoided harm if the damage was substantial? I would sue you in a flash, he said, but what if I have a good record among surgeons with generally excellent outcomes and conscientious care? That wouldn't matter, he said. The only thing that mattered is what I did in the case in question. It's like driving a car, he explained. I could have a perfect driving record, but if one day I ran a red light and hit a child, then I'm negligent, he said. Lang insisted that he is not on a crusade against doctors. He faced 3 malpractice suits himself when he was a surgeon. One involved an arthroscopy that he performed on a young woman with torn cartilage in her knee from a sports injury. Several years later, he said, she sued because she developed arthritis in the knee, a known, often unavoidable outcome. Against his wishes, the insurer settled with the patient for what Lang cost nuance money, $5,000 or so, because it was cheaper than fighting the suit in court. In another case, a manual laborer with a wrist injury that caused numbness in 3 fingers sued because Lang's attempted repair made the numbness worse and left him unable to work. Lang said he had warned the patient that this was a high-risk surgery. When he got in, he found the key nerves encased in a thick scar. Freeing them was exceedingly difficult. It's like trying to peel Scotch tape off wallpaper, he said, and some nerve fibers were unavoidably pulled off. But the insurer wasn't certain that the argument would prevail at trial and settled for $300,000. Both cases seemed unmerited, and Lang found them as exasperating as any doctor would. The third case, however, was the result of a clear error, and although it took place 2 decades ago, it still bothers him. I could have done more, he told me. The patient was a man in his 60s whom Lang had scheduled for a knee replacement. A few days before the surgery, the man came to Lang's office complaining of pain in his calf. Lang considered the possibility of a deep vein thrombosis, a blood clot, in the leg, but dismissed it as unlikely and ordered no further testing. The patient did have a DVT, though, and when the clot dislodged 2 days later, it traveled to his lungs and killed him. Lang's insurers settled the case for about $400,000. If I had been on the plaintiff's side, would I have taken the case against me? He said. Yes. Being sued was devastating, Lang recalled. It is an awful feeling. No physician purposefully harms the patient. Yet he insists that, even at the time, he was philosophical about the case. Being sued, although it sort of sucks the bottom out of you, you have to understand that it is also the cost of doing business. I mean, everybody at some time in his life is negligent. Whether he's a physician, an auto mechanic, or an accountant, negligence occurs, and that's why you have insurance. If you leave the oven on at home and your house catches fire, you are negligent. It doesn't mean you're a criminal. In his view, the public has a reasonable expectation. If a physician causes someone serious harm from substantial care or a substandard care or an outright mistake, he or her should be held accountable for the consequence. The three cases that Lang faced as a doctor seem to me to epitomize the malpractice debate. Two of the three lawsuits against him appear unfounded, and whatever Lang says now, the cost to our system in money and confidence is nothing to dismiss. Yet one of them concerned a genuine error that cost a man his life. In such cases, don't doctors owe something to patients and their families? I really enjoyed reading those case studies because it gives me better understanding of how doctors should approach issues and avoid doing harm to patients and try to be less negligent. And it also, every time when I'm driving a car, I keep telling myself, oh, you need to focus, you need to be cautious, because you don't want to end up in any traffic accident, because that would be very bad. So I know not making errors is really hard, and we all make mistakes because that's what makes us human, and trying to just reduce that to the best we can is all that we can do. I'm gonna end here because this chapter is actually quite long, so we'll talk about the rest of the chapter next time. Thanks for being with me.